We also ask that you reconsider your funding obligation or the obligation you've taken on to fund the Vera Institute's pretrial services program. Precious public money is being used, again, to support an entity that this city has absolutely no obligation to fund. The work that the Vera Institute does, I'm not saying it's not good work again, but it's duplicitous. The information that's provided to us by Vera Institute's pretrial services is the same information that has always been provided to us by the district attorney's office and the public defender's office. The district attorney's office gives us a full rendition of a person's criminal history. The public defender's office has, I guess they're called paralegals that work within the court. They interview all the inmates. They ask them for their family information. They confirm employment. They call family members about bonds. So we think that is work that is being duplicitous, We believe these two costs are like luxuries more than they are necessities.
Let me ask you about the Vera Institute. You indicated that their services were duplicative in the sense that they're doing what the public defenders and the DA should do in terms of providing you with information to make decisions about retaining people in jail. Is that what you said?
I'm saying that that is the work that is presently being done, and I guess you could say I don't know if it has to be done by these people, these individuals. That is work that is presently being done, sir. We have an assistant district attorney who's going to give us an entire rap sheet on that person. They'll go as long as we let them. We have the public defender's office who has paralegals stationed in our court. Those individuals are in and out of court constantly talking to the inmates. They're getting background information, calling their jobs to see if they have a job, calling family members about their bond so they can quickly get them out if they are, given a bond. So what I'm saying is that is a lot of what is being done. Yes, that is information we're currently being provided without the Vera Institute's involvement.
I'm curious, does that mean you get the information twice?
Yes.
So the DA, the public defender gives you the information, the Vera Institute gives you the same information?
Yes. They're going to give us that same rap sheet. See, a DA is going to want to make sure a judge hears this person's history. They're trying to get a high bond. Judge, this guy has charges and convictions from Texas, Arizona, Louisiana, and they are as follows. They're making a record for themselves. So they're going to make sure we have every piece of information we need on those individuals.
And just to be clear, the information given to you by the DA and the public defender is of record. Is that correct? I mean, it becomes part of the record.
If they place it on the record, if they say, listen, Judge, I know for a fact as a public defender, we've confirmed that, John works at Wendy's. We talked to the manager. He does have a job there. He has been there for 2.5 years. That kind of information they will place on the record.
And I assume as a judge, when you're making the decision about release or retaining the person, you make that decision based on information that's in the record. Is that correct?
On their criminal history, the first thing we're to look at is that person's, the probability of that person returning to court. That is the #1 issue. Then we look at the charge, the severity, the weight of the evidence, and a criminal history for sure.
Judges are required by law to make their decisions based on the information that is in the record. Is that correct?
Yes.
That's correct.
Let me tell you why many people are very happy with the Vera Institute, because there's a feeling that as a result of their work, fewer people are retained unnecessarily in jail. And I guess I need to ask you, in your court, does their information or recommendation affect your determination as to whether or not you will release a person?
It varies. I don't get a Vera report on every single. You got to understand, we're getting 80% of every charge that comes. Now, not every charge that comes to court is an arrest, but we're getting the municipal arrest and the state arrest. We're not getting anything from Vera on any municipal charges, none whatsoever. So it's only on the state misdemeanors. I don't always have a Vera report on every single state misdemeanor. I don't know if you gentlemen have it, but I don't. So I don't rely on it sometimes because I don't have it. And, you know, I'm leery. I mean, and I realize that could be a fluke, the whole Mother's Day shooting, but lots of people were shot. That person had a very low rating. So I tend to be more skeptical when I look at these reports from the Vera, from Vera. And at the end of the day, I'm the judge that made the bond that was too low for a particular person with a particular criminal background that should have had a higher bond. I can't blame Vera. I can't pass the buck. I can't say, oh, well, Vera told me that they were ranked number 2 risk. Nobody's going to want to hear that. The public's going to ask me why I did that. So I think that I'll look at it, but then I'll make my own decision. And that's my obligation. It's not Vera's obligation.
Now, one other question. There was some previous discussion that suggested Vera's current practice is to show judges their report, but not allow judges to keep it and put it either in the record or on the record. Is that the way it works?
Not for me.
Not for me.
It goes in the record, or
When
That's where I find it.
they send it to me,
I
when I
find
get one,
I
when
get them, yeah. I
when
get
I-
them
Okay.
very infrequently,
All
but
right.
they're in the record.
and I'll make a notation, for instance, in everything in my court, Mr. Gray goes on the record. So the DA's office goes through it, and I will make for the record, if I have a report from Vera and it's a 2, a 3, a 5, a 7, I'll put in right next to where I make the bond, I'll do a circle and I'll put the number there so that it would tell me that there was a Vera report, it made a suggestion relative to this person, and it's something to be considered. But ultimately, just like Judge Chauvin says, that's a decision that the judge is going to have to make, and that's what I believe we've been elected to do. But be that as it may.
okay.
Ms. Head.
Thanks. I have a few questions. One is related to the Vera reports. I think the concept of having a third party do an in-depth analysis into pretrial detainees, current life status, criminal history, to be able to help you formulate an opinion. I agree completely with the judges that it's your call and you've got to make a judgment call. It's not a computer analysis. It's a great tool. The question is, there's been a lot of criticism of and questions about Vera in the past, and I think one of the best ways we could determine as policymakers and funders as to whether or not that's a program we need to continue to move to work with is to get all of the Vera reports and have, for example, maybe the Inspector General look at that to determine whether or not the information was accurate, for example, that they had. Whether or not the form is in line with what considerations are. If you look at best practices, and of course that's a I'm sure a fight right there. What's best practice is it? Best practices is what's the range of criminals when they put it's from a 2 to a whatever it is, a 20. Is there a bell curve where most people are in the middle, or is it very few people are at the very end? How does that work? Just to give us some a view from taking a step back, but being able to look at all of the reports together rather than pick and choose one outlier. Because, of course, with the volume of pretrial detainees that you deal with, pretrial defendants that you deal with, there are going to be mistakes made no matter what the group is, and picking 1 or 2 out to show that it was done perfectly or that they were done horribly, I don't think is fair to the judges or to the Vera Institute. So I forgot which judge said this, that y'all don't have a problem with the Vera documents, the analysis that they do, the forms being provided to the public as long as there's not another privacy issue, not a juvenile, things like that. But do y'all have any problem with their information, their papers being made public?
I don't.
I don't.
know.
I
I
think
can't
that would be up to the defendant, because it's the defendant's personal information that's being put into the record.
Yes, if I
I don't
might.
think there's medical information. I mean,
Okay.
which
Yes.
brings you the HIPAA
So
issue
what there is,
in.
I
don't
think
remember if
I think
saw
the
medical.
first 4 pages, which is what is given to the DA and the public defender. Well, the public defender is given the whole thing because it's their client, or the private attorney, one or the other. But I think the first 4 pages, which is which is the assessment, the rating, and all of that, is given to the judge and the DA and all. And that part could be in the record. As a matter of fact, it often is, and it's only because when this pretrial services program was being created, there were many, many people involved in the working group, Vera Institute, the Sheriff's Office, the judges from Criminal District Court. I don't know if you guys were involved in it. No? Because, okay, and the DA, the public defender, and that group decided that the report wouldn't go in the record. So, so it really,
Yeah, well, it's again, we weren't included in that, so no one told
Yeah.
us.
Okay.
I
Some of
don't
them are
know.
floating around in our records.
So just to bring it
So-
to the most basic level, if y'all were asked, assuming there is no other legal prohibition, like a HIPAA or whatever, you don't see any reason that particularly a third party who can do this analysis of the accuracy of a statistically appropriate sample, and just do the chart, a graph to show us where people fall. You
Well,
would-
I mean, even if it's decided that it can't be public from our standpoint, why can't Vera provide that information? It wouldn't seem to be
Well, I mean,
conflict for them.
right.
I would
You don't
also
have an
say
issue.
we just had the National Institute of Corrections come in, and they talked about their assessment last week, and some of what you just asked about is in it, and it was in the PowerPoint that Vera had, but their report was supposed to be done, but it was held up because of the shutdown, the federal shutdown. So that should be coming out like this week.
I'm hearing good news that we can get, that
Yes, it-
probably that information can be put out.
Yes, and the National Institute of Corrections statements at the meeting last week were, for the most part, that the risk assessment tool is within the national standards, except for that it actually weights the current charge, and I believe something else, a little heavily, so that it weights more heavily than what they'd call the best standards.
Well, if we're going to have to weigh something in a city like New Orleans more heavily, I certainly think we should weigh it more
I
heavily. But,
totally agree, totally agree.
But there are some specific, questions I have, again, about the care that is taken to confirm the accuracy of information provided by defendants.
That's the key issue for us, too,
yes,
because they're getting that information from the defendant.
Right, and you can get the defendant from them, but you do that check. You do the computer check to see if, in fact, there's an address where they say they live, and if there's an address where they live, and then you can get that on the assessor's website. So anyway,